Good morning, everyone. Now, let's start with the next chapter of Laxmikant Union and its territory. Article 1 to 4 under Part 1 of the Constitution deals with the Union and territory. Union of States. Article 1 describes India, that is Bharat, as a union of states rather than the federation of states. This provision deals with the two things: one, the name of country, and two, type of polity. There was no unanimity in the Constituent Assembly with regard to the name of country. Some members suggested the traditional name Bharat, while others advocated a modern name India. Hence, the Constituent Assembly had to adopt a mix of both, that is, India, that is Bharat. Secondly, the country is described as a union although its constitution is federal in structure. According to Dr. B.R. Ambedkar, the phrase Union of States has preferred to the Federation of States for two reasons. One, the Indian Federation is not the result of agreement among states like the American Federation, and two, the states have no right to secede from the Federation. The Federation is an union because it is indestructible. The country is an integral whole and divided into different states only by convenience of administration. According to Article 1, the territory of India can be classified into three categories. First, territories of state, union territories, and territories that may be acquired by Government of India at any time. The name of the states and the union territories and their territorial extent are mentioned in the first schedule of Constitution. At present, there are 28 states and 9 union territories. The provisions of constitutions pertaining to the states are applicable to all the states in the same manner. However, the special provisions under Part 21 applicable to the states of Maharashtra, Gujarat, Nagaland, Assam, Manipur, Andhra Pradesh, Telangana, Sikkim, Mizoram, Arunachal Pradesh, Goa, and Karnataka overrides the general provision related to the states as a class. Further, the fifth and sixth schedule contains separate provisions with respect to the administration of scheduled areas and tribal areas within the states. Notably, the territory of India is wider expression than the Union of India. This is because the latter includes only states while former includes not only states but the union territories that may be acquired by the Government of India at any future time. The states are members of the federal system and share the distribution of powers with the center. The union territories and the acquired territories, on the other hand, are directly administered by central government. Being a sovereign state, India can acquire foreign territories the models according to the modes recognized by international law, that is, cession, following treaty, purchase, gift, lease, or plebiscite. Occupation, hitherto unoccupied by recognized ruler. Conquest or subjugation. For example, India acquired several foreign territories such as Dadra and Nagar Haveli, Goa, Daman and Diu, Puducherry, and Sikkim since the commencement of the Constitution. The acquisition of these territories are discussed later in this chapter. Article 2 empowers the Parliament to admit into Union of India or establish new state on such terms and conditions as it thinks fit. The Article 2 grants two powers to the Parliament. A. The power to admit into the Union of India new states, and B. The power to establish new states. The first refers to the admission of states which already in existence, while second refers to the establishment of states which were not in existence before. Notably, Article 2 relates to the admission and establishment of new states that are not part of Union of India. Article 3 on the other hand relates the formation of changes in the existing states of the Union of India. In other words, Article 3 deals with the internal readjustment inter se of the territories of constituent states of the Union of India. Parliament's power to reorganize the states. Article 3 authorizes the Parliament to a. Form a new state by separation of territory from any state or by uniting two or more states or the part of states or by uniting any territory to the part of any state. B. Increase the area of any state. C. Diminish the area of any state. D. Alter the boundaries of any state. And E. Alter the name of any state. However, Article 3 lays down two conditions in this regard. 1. A bill contemplating the above changes can be introduced in the Parliament only with the prior recommendation of the President. And 2. Before recommending the bill, the President has to refer the same to the state legislature concerned for expressing its views within the specified period. Further, the power of Parliament to form new states includes the power to form new state or union territory by uniting the part of any state or union territory to any other state or union territory. The President or Parliament is not bound by the views of state legislature and may either accept or reject them, even if the views are received in the time. Further, it is not necessary to make a fresh reference to the state legislature every time an amendment to the bill is moved and accepted in the Parliament. In the case of Union territory, no reference need to be made to the concerned legislature to ascertain its views, and Parliament can itself take any action as it deems fit. It is thus clear that the Constitution authorizes Parliament to form new states or alter the areas, boundaries, or the names of existing states without their consent. In other words, the Parliament can redraw the political map of India according to its will. Hence, the territorial integrity or continued existence of any state is not guaranteed by the Constitution. Therefore, India is rightly described as the indestructible union of destructible states. The union government can destroy the states, whereas the state governments cannot destroy the union. In USA, on the other hand, the territorial integrity or continued existence of the state is guaranteed by the Constitution. The American federal government cannot form new state or alter the borders of existing states without the consent of the state concerned. That is why the USA is described as an indestructible union of these indestructible states. Moreover, the Constitution, Article 4 itself declares that the laws made for admission or establishment of new states under Article 2 and formation of new states and alteration of states' boundaries or the names of existing states under Article 3 are not to be considered as amendments to the Constitution under Article 368. This means that such laws can be passed by simple majority and can by ordinary legislative process. Does the power of Parliament to diminish the area of state under Article 3 include also the power to cede Indian territory to the foreign country? This question comes up for the examination before Supreme Court in the reference made by the President in 1916. The decision of central government to cede the part of territory known as the Berubari Union in West Bengal to Pakistan led to a political agitation and controversy, and thereby the necessitated the presidential reference. The Supreme Court held that the power of Parliament to diminish the area of state under Article 3 does not cover the cession of the Indian territory to foreign country. Hence, the Indian territory can be ceded to the foreign state only by amending the constitution under Article 368. Consequently, the Ninth Constitutional Amendment Act 1960 was enacted to transfer the said territory to Pakistan. On other hand, the Supreme Court in 1969 ruled that the settlement of boundary dispute between India and another country does not require a constitutional amendment. It can be done by executive action as it does not involve the cession of the Indian territory to the foreign territory. Exchange of territories with the Bangladesh. The 100th Constitutional Amendment Act 2015 was enacted to give effect to the acquiring certain territories of India and transfer of certain other territories to Bangladesh. In pursuance of the agreement and the protocol entered into between the government of India and Bangladesh. Under this deal, India transferred 111 enclaves to the Bangladesh, while Bangladesh transferred 51 enclaves to India. In addition to deal with involved the transfer of adverse possessions and the demarcation of 6.1 kilometer undemarked border stretch. For this, three purposes. The amendment modified the provisions related to the territories of four states Assam, West Bengal, Meghalaya, and Tripura in the first schedule and the constitution. The background of these amendments are as follows. First, India and Bangladesh have a common land boundary of approximately 4,096.7 km. The India East Pakistan land boundary was determined as per Radcliffe Award of 1947. Disputes arose out of some provisions in the Radcliffe Award which were to be sought to be resolved through the Bagay Award of 1950. Another effort was made to settle these disputes by Nehru Noon Agreement in 1958. However, the issues relating to the division of Perubari Union was challenged before the Supreme Court. To comply with the opinion rendered by the Supreme Court, the Constitution, that is Ninth Amendment Act 1960, was passed by the Parliament. Due to the continuous litigation and the other political developments at the same time, the Constitution Ninth Amendment Act 1960 could not be notified in respect to the territories of former East Pakistan, that is presently Bangladesh. Second, on May 16, 1974, the agreement between India and Bangladesh concerning the demarcation of the land boundary and the related matters was signed between both the countries to find the solution to the complex nature of border demarcation. The agreement was not ratified as it involved inter alia the transfer of territories which requires the constitutional amendment. In this connection was In this connection, it was also required to identify the precise area on the ground which could be transferred. Subsequently, the issues relating to the demarcation of undemarcated boundary, the territories in adverse possession and exchange of the enclaves were identified and resolved by signing the protocol on the September 6, 2011, which forms the integral part of the land boundary agreement between India and Bangladesh, 1974. The protocol was prepared, which supported the occurrences of the concerned state government of Assam, Meghalaya, Tripura, and West Bengal. Evolution of states and union territories. Integration of princely states. At the time of independence, India comprised two categories of political units, namely British provinces under the direct rule of British government and the princely states under the rule of native princes but subject to paramountcy of British crown. The Indian Independence Act of 1947 created two independent and separate dominions of India and Pakistan and gave three options to the princely states, that are joining India, joining Pakistan, or remaining independent. Of the 552 princely states situated within the geographical boundaries of India, 549 joined India and remaining three, that is Hyderabad, Junagadh and Kashmir, refused to join India. However, in course of time they were also integrated with India. Hyderabad by means of police action, Junagadh by means of referendum, and Kashmir by means of instrument of accession. In 1950, the constitutions contained a fourfold classification of the states and territories of Indian Union, Part A, Part B, and Part C states, and Part D territories. In all, they number 29. Part A states comprise the nine erstwhile governors' provinces of the British India. Part B states consisted as the nine erstwhile princely states with the legislature. Part C states consisted of erstwhile chief commissioners' provinces of British India and some of the erstwhile princely states. This Part C, in all 10 in number, was centrally administered. The Andaman and Nicobar Islands were kept as a solitary Part D territories. Dhar Commission and JVP Committee. The integration of princely states with the rest of the India has purely an ad hoc arrangement. There has been a demand from different religions, particularly South India, for the reorganization of the states on the linguistic basis. Accordingly, in June 1948, the Government of India appointed the Linguistic Provinces Commission under the chairmanship of S.K. Dhar to examine the feasibility of this. The new commission submitted its report in December 1948 and recommended the reorganization of the states on the basis of administrative convenience rather than linguistic factor. This created much resentment and led to the appointment of another linguistic provinces committee by Congress in December 1948 itself to examine the whole question afresh. It consisted of Jawaharlal Nehru, Vallabhbhai Patel, Pattabhi Sitaramaiah, and hence was popularly known as JVP Committee. It submitted its reports in April 1949 and formally rejected the language as a basis of reorganization of the states. The territory of India in 1950. States in Part A: Assam, Bihar, Bombay, Madhya Pradesh, Madras, Orissa, Punjab, United Provinces, and Bengal. States in Part B: Hyderabad, Jammu and Kashmir, Madhya Bharat, Mysore, Patiala and East Punjab, Rajasthan, Saurashtra, Travancore and Cochin, and Vindhya Pradesh. States in Part C: Ajmer, Bhopal, Bilaspur, Kunj Bihar, Kurg, Delhi, Himachal Pradesh, Kutch, Manipur, and Tripura. And territories in Part D: Andaman and Nicobar Islands. The original parts of the Constitution dealing with the states and territories. Part 6. Original heading: States. In Part A of the first schedule, articles covered 152 to 237. Part 7th, the states in Part B of the first schedule, article covered 238. Part 8. The states in Part C of the first schedule. Article covered 239 to 242. Part 9. The territories in Part D of the first schedule and the other territories are not specified in that schedule. Article 243. However, in October 1953, the government of India was forced to create the first linguistic state known as Andhra Pradesh by separating the Telugu speaking areas of Madras state. This followed a prolonged popular agitation and the death of Potti Sriramulu, a congressperson of standing, after 56 days of hunger strike in this cause. Fazal Ali Commission. The creation of Andhra state intensified the demand from other regions for the creation of states on the linguistic basis. This forced the Government of India to appoint, in December 1953, a three-member state reorganization commission under the chairmanship of Fazal Ali to re-examine the whole question. Its other two members were K.M. Panikar and H.N. Kunzru. It submitted its reports in September 1955 and broadly accepted the language as the basis of reorganization of the states, but it rejected the theory of one language, one state. Its view was that the unity of India should be regarded as the primary consideration in any redrawing of country's political units. It identified four major factors that can be taken into account in any scheme of the reorganization of the states. A. Preservation and strengthening of the unity, security of the country. B. Linguistic and cultural homogeneity. C. Financial, economic, and administrative considerations. And D. Planning and promotion of the welfare of people in each state as well as of the nation of the whole. The Commission suggested the abolition of fourfold classification of the states and territories under the original constitution and creation of 16 states and 3 centrally administered territories. The Government of India accepted these recommendations with certain minor modifications. By the State Reorganization Act of 1956 and the 7th Constitutional Amendment Act of 1956, the distinction between Part A and Part B of the states done away with and Part C states were abolished. Some of them were merged with the adjacent states and some other were designated as union territories. As a result, 14 states and 6 union territories were created on November 1, 1956. The States Reorganization Act of 1956 established the new state of Kerala, merging to the Travancore, the Cochin states with the Malabar district of Madras states and Kasaragod of South Kannada, that is Dakshin Kannada. It merged the Telugu speaking areas of Hyderabad state with Andhra Pradesh to create the Andhra Pradesh state. Further, it merged the Madhya Bharat state. Similarly, it merged the Saurashtra state and Kutch state into the state of Bombay. Into that state of Bombay, Kurg state put into that of the Mysore state, the Patiala and East Punjab Union, Pepsu into that of the Punjab state, and the Ajmer state into that of the Rajasthan state. Moreover, it created a new union of Lakshadweep, Minicoy, and Amindavi Islands from the territories detached from the Madras state. New states and union territories created after 1956. Even after the large-scale reorganization of the states in 1956, the political map of India underwent the continuous changes due to the pressure of political agitations and the political conditions. The demand for the creation of some more seats on the basis of the language or cultural homogeneity resulted into the bifurcation of existing states. Maharashtra and Gujarat. In 1960, a bilingual state of Bombay was divided into the two separate states of Maharashtra and for Marathi speaking people and Gujarat for Gujarati speaking people. Gujarat was established as a 15th state of Union Territory. Dadra and Nagar Haveli, 15th state of Indian Union. Dadra and Nagar Haveli. The Portuguese ruled this territory until the liberation in 1954. Subsequently, the administration was carried out 1961 by an administrator chosen by the people themselves. It was convened into the Union Territory of India, 100th Constitutional Amendment Act of 1961. Goa, Daman and Diu. India acquired these territories from Portuguese by means of police action in 1961. They were constituted as a union territory by 12th Constitutional Amendment Act of 1962. Later, in 1918, Goa was conferred a statehood. Consequently, the demand for Diu was made a separate union territory. Puducherry. Territory of Puducherry comprises the former French establishment in the India known as Puducherry, Karaikal, Mahe, and Yanam. The French handed over this territory to India in 1954. Subsequently, it was administered by the 14th as a acquired territory till 1962, and when it was made a union territory in 14th Constitutional Amendment Act. Nagaland. In 1963, the state of Nagaland was formed by taking Naga Hills and Rensang area out of the state of Assam. This was done to satisfy the movement of hostile Nagas. However, before giving the Nagaland the status of 16th state of Indian Union, it was placed under the control of Governor of Assam in 1961. Haryana, Chandigarh, and Himachal Pradesh. In 1966, the state of Punjab was bifurcated to create Haryana, the 17th state of Punjab, 17th state of Indian Union, and the Union Territory of Chandigarh. The followed demand for the separate Sikh state, that is a homeland, Punjabi Sabha raised by the Akali Dal under the leadership of Master Tara Singh. The Punjabi speaking areas constituted into the unlingual state of Haryana, and hill areas were merged with the adjoining union territories of Himachal Pradesh. In 1971, the union territories of Himachal Pradesh was elevated to the status of a state. Manipur, Tripura, and Meghalaya. In 1972, a political map of northeast India underwent a major change. Thus, the two union territories of Manipur and Tripura and the sub-state of Meghalaya got statehood, and two union territories of Mizoram and Arunachal Pradesh, originally Northeast Frontier Agency (NEFA), came into being. With this, the number of states of the Indian Union increased to 21. Manipur 19th, Tripura 20th, Meghalaya 21st. Initially, the 22nd Constitutional Amendment Act of 1969 created the Meghalaya as an autonomous state or sub-state within the state of Assam with its own legislature and Council of Ministers. However, this did not satisfy the aspirations of the people of Meghalaya. The Union territories of Mizoram and Arunachal Pradesh were also confirmed out the Mizorams of the Assam. Sikkim. Till 1947, Sikkim was the Indian princely state ruled by Chogyal. In 1947, after the lapse of British paramountcy, Sikkim became a protectorate of India, whereby the Indian government assumed the responsibility for the defense, external affairs, and the communications of Sikkim. In 1974, Sikkim expressed that its desire for the greater association with India. Accordingly, the 35th Constitutional Amendment Act of 1974 was enacted by the Parliament. This amendment introduced a new class of the state under this constitution by conferring on the state of Sikkim a statehood under status of an associate state of the Union Territory, of the Indian Union. For this purpose, a new Article 2A and a new schedule, 10th schedule, containing the terms and conditions for the association, were inserted in the Constitution. This experiment, however, did not last long, as it could not fully satisfy the aspiration of the people of Sikkim. In a referendum held in 1975, they voted for the abolition of institution of Chogyal and Sikkim becoming the integral part of India. Consequently, the 36th Constitutional Amendment Act 1957 was enacted to make the Sikkim a full-fledged state, one state of the Indian Union, and the 22nd state. This amendment amended the first and fourth schedules of the Constitution and added a new article of 371F to provide the certain special provisions with respect to the admission of Sikkim. It also replaced the Article 2A and the 10th schedule that were added by 35th Amendment Act of 1974. Mizoram, Arunachal Pradesh, and Goa. In 1987, three new states of Mizoram, Arunachal Pradesh, and Goa came into being as 23rd, 24th, and 25th states of Indian Union, respectively. The Union Territory of Mizoram was conferred the status of full state as a sequel to the signing of Memorandum of Settlement, Mizoram Peace Accord Mizoram Peace Accord in 1986 between the central government and Mizo National Front, ending the 2 decades-old insurgency. Arunachal Pradesh had also been a union territory from 1972. The state of Goa was created by separating the territory of Goa from the Union territory of Goa, Daman and Diu. Chhattisgarh, Uttarakhand, and Jharkhand. In 2000, three new states of Chhattisgarh, Uttarakhand, and Jharkhand were created out of the territories of Madhya Pradesh, Uttar Pradesh, and Bihar, respectively. This became 26th, 27th, and 28th states of Indian Union, respectively. Telangana. In 2014, a new state of Telangana came into existence as the 29th state of Indian Union. It was carved out of the territories of Andhra Pradesh. The Andhra State Act of 1953 formed the first linguistic state of India, known as the State of Andhra, by taking out Telugu-speaking areas from the state of Madras, which is now Tamil Nadu. Kurnool was the capital of Andhra state and the state high court was established at Guntur. The States Reorganization Act of 1956 merged the Telugu speaking areas of Hyderabad state with the Andhra state to create the enlarged Andhra Pradesh state. The capital of the state was shifted to Hyderabad. Again, the Andhra Pradesh Reorganization Act of 2014 bifurcated Andhra Pradesh into two separate states, namely Andhra Pradesh Residuary and the Telangana. Jammu and Kashmir and Ladakh. Till 2019, the erstwhile state of Jammu and Kashmir had its own constitution and thus enjoyed a special status by the virtue of Article 370 of the Constitution of India. In 2019, this special status was abolished by the presidential order known as the Constitution application to the Jammu and Kashmir Order 2019. This order superseded the earlier order known as the Constitution application of Jammu and Kashmir Order of 1954. The 2019 order extended all provisions of the Constitution of India to Jammu Kashmir also. However, inoperative Article 370 continued to remain in text of the Constitution of India. Further, the Jammu and Kashmir Reorganization Act of 2019 bifurcated the erstwhile state of Jammu and Kashmir into two separate union territories, namely the Ladakh, namely the Union Territories of Jammu and Kashmir and the Union Territories of Ladakh. The Union Territory of Jammu and Kashmir comprises all the districts of the erstwhile state of Jammu and Kashmir except the Kargil and Leh district which have gone to the Union Territory of Ladakh. Thus, the number of states and the Union Territories increased from 14 and 6 in 1956 to 28 and 9 in 2019, respectively. Change of the names. The names of some states and union territories have also been changed. The United Provinces was the first states to have created a new name. It was renamed as Uttar Pradesh in 1950. In 1969, Madras was renamed as Tamil Nadu. Similarly, in 1973, Mysore was renamed as Karnataka. In the same year, Lakshadweep, Minicoy, and Amindavi Islands were renamed as Lakshadweep. In 1992, the Union Territory of Delhi was designated as the National Capital Territory of Delhi without being conferred as a status of full-fledged state by 69th Constitutional Amendment Act of 1991. In 2006, Uttaranchal was renamed as Uttarakhand. In the same year, Pondicherry was renamed as Puducherry in 2011. Orissa was renamed as In 2011, Orissa was renamed as Odisha. Thank you. Here we complete with the chapter number 5. If at any point of time in your preparation, if you find these audiobooks or videos helpful, then don't forget to like and share these videos, and don't forget to subscribe to my channel YouTube Shorts. Thank you. Have a good day.